My name's Marc Victor. I'm a criminal defense attorney here in Arizona for about the past 25 years. And I've been defending people in cases throughout the state, misdemeanor cases, felony cases, as serious as first-degree murder with the death penalty alleged, which I've tried on several occasions, all the way down to, like I like to say, crazy little misdemeanors throughout our state. I also do federal cases in the state as well as out of the state, including appeals, where I've argued at the Ninth Circuit. So we're gonna talk about the justice system today, and I wanted to have as comprehensive a discussion from different points of view as possible. So I asked a couple of other attorneys here who work in the criminal justice system, both of whom I consider friends, both of whom I consider excellent lawyers, both of whom I consider very, very well educated about the Constitution and American history and how our system works. And all three of us have ideas about how our system ought to work. So seated at the table here to my immediate left is Bill Montgomery. Bill is the current elected Maricopa County attorney. So one way to say it is he is the chief prosecutor in the county. And Bill, if you want to say a few things about your background, or yeah, why don't you introduce yourself?
Thanks for deferring. I graduated from ASU's College of Law in 2001 and had the distinct pleasure and opportunity to work as a prosecutor my third year. I received the Truman Young Prosecution Fellowship at that time. And then I worked at the county attorney's office as a line prosecutor and a supervisor for about 6 years before I ran for the office in 2010, and I've served in the position since then. I'm looking forward to the conversation. I think whenever we the people have delegated to the government the authority to maintain civil order, having conversations about how that works and keeping government in its lane are always beneficial.
So I should say, those of you who know me know that I generally come from the libertarian perspective. Bill comes from a conservative perspective. Sitting next to Bill is Bob McWhirter, another friend of mine, excellent criminal defense lawyer. I'm going to let Bob say a few things about himself, but as you might imagine, he comes from the left or progressive side of things.
Okay.
Is that fair?
It depends on the issue, but I think for purposes of our panel today, it makes the discussion more interesting, so we can go from there.
Maybe I've convinced him to be a libertarian. I don't know.
I'll be glad to be a liberal for today. How's that? Yeah, I have a kind of a varied background. As many of you probably know, I'm a constitutional historian. I've written several books on the history of the Bill of Rights and the Constitution. I'm currently writing a history of the 13th, 14th, and 15th Amendments. My book on the history of the Bill of Rights is Bills, Quills, and Stills. You can find it on Amazon. If I sell enough of that, I can afford to send my kids to trade school, so that would be good. I will tell you also that Bill Montgomery owes me a great debt because I wrote the bar complaint against his predecessor, which then, of course, allowed Bill Montgomery a place to run, so that's good. Which is not totally true. That's not totally the chronology, but at any rate, so there's that. So is that sufficient?
Yeah, with that. So I think we're going to start. We're planning sort of an informal discussion. We had lunch very recently, the three of us, and we talked a little bit about this panel, and it turns out we didn't run out of things to talk about during the lunch. So I thought something sort of unstructured makes sense, and if people have questions, I think informally as we go through that makes sense. So I think all three of us agreed to sort of start with what we like about the justice system here, what works well, how we think things are going, that kind of thing. So let's start with Bill, just to throw out a few ideas about what you think works well in our criminal justice system.
Sure, and as a starting point, I would say that when we think about the criminal justice system, we have to be pretty precise about which aspect or which level of the criminal justice system we're talking about. Because writ large, we do not have a criminal justice system in our country. We have a sort of unified system at the federal level where all the functions of investigation, prosecution, defense, courts, and incarceration exist in either the executive or judicial branches. But once you get down to the state level, we have 50 different criminal justice systems, one for each state, And then there's an aspect of that system that also exists at about 3,000 counties. And then below that, another aspect of it for the roughly 19,000 municipalities that we have around the country. So if I focus my remarks about how our criminal justice system is set up in Arizona, and then my experience of that at the county level, where I'm sort of at the intersection. I work with municipal agencies that predominantly perform the investigative function. At the county level, we predominantly perform the prosecution and defense functions with a trial court. And then at the state level is where you pretty much have the appellate court system and then incarceration through the Department of Corrections. For us in Arizona, I would say that we do a good job in looking at the challenges we have and the environment in which crime is committed, and then trying to be as finely tuned as we can be in assessing penalties and incarcerating the right type of offender, and happy to talk more about that too, in order to produce public safety, which is the first responsibility of government. And in doing that, offering as many programs and services as we can within the criminal justice system to try to identify who's an individual that is entitled or would be best served with a diversion or deferred prosecution program, those who could be served by probation, ultimately then those who are identified either because of the crime they committed or the repetitive nature of their criminal history to go to prison. Can we do better? Absolutely. And I'm sure that's where we'll wind up spending the majority of our conversation, identifying areas where criminal justice system outcomes can certainly be improved and requires some redesign and a commitment on the part of the legislature and on the part of the community to go through some re-engineering, which will carry some cost.
Bob, what do you think? What works well in our system?
I think the system, when it works best, does a fairly good job of assessing responsibility for crimes. What I think, and I think there's a structure. I have also got a tremendous amount of experience working in Latin America with emerging criminal justice systems, and we are what they aspire to. So most of my arguments about the criminal justice system are defending what exists more than anything else from the encroachment of prosecutors. But to be clear, I think that there is an acceptance of these basic premises about the criminal justice system and the checks and balances that it entails. We argue about the scope of the Fifth Amendment. We don't argue whether there should be a Fifth Amendment. We argue about the scope of the Fourth Amendment. We don't argue whether that principle should be changed or should not exist. That is fundamental, and that is fundamentally good about the criminal justice system. The playground we're in has been defined and well-defined, and that's what is important to preserve, and that's what is best about the system in a broader term.
So I actually agree with what both Bill and Bob said, but I sort of approach the question slightly differently in terms of our justice system. I like to break our system down into really two portions. One, the procedural side, which I would describe as how we process people through the system, how you get a fair trial and all that. With the other side, the substantive side, what the law actually is. In terms of the procedure, I actually think we do a pretty good job. No, I don't think our system is rife with corruption or fraud. I can tell you in 25 years, I have never once had an occasion to think that the judge was on the take or something like that, or anybody, the judge even had sort of an inappropriate, what we call ex parte conversation. Judges are required to talk to both sides. They don't get secret meetings with one side or the other. We generally, we don't see fraud in our system. I think people, for the most part, get treated fairly. I know there's lots of talk about our system being racist. I can tell you in 25 years of looking for that particular argument, I have never once made it. And those of you who know me know I'm not afraid to advance an argument, but I have never had one occasion to stand up and say, I think that this person, because of the color of their skin or their ethnic background or something like that, they were being treated any differently. But just to be sure, I've got a couple of friends who are also friends with these two up here who are black criminal defense attorneys, and I asked them, I said, hey, do you guys think that our system is racist? And both of them laughed. Both of them said, we have not had one experience anywhere in Arizona's criminal justice system. So I think in terms of our procedure, people generally get a fair trial. Our rules of evidence are pretty good. I think the judges do a very good job of, if you get charged with a crime in this state and you go to trial, for the most part, you're going to get a fair trial. So I think our procedure is pretty good. The substantive criminal law, and this is what maybe will get us into some of the problems, to me this is the main problem. I'm not saying there aren't things on the procedure side that we could tweak and fix, there are. But if you ask me, maybe what the number one problem in our system is, it's crushing volume. That's the problem, crushing volume of cases. And in my opinion, the reason we have crushing volume of cases is because we are still embroiled in this ridiculous drug war. And so I would throw out on the table, for starters, something to discuss in terms of a problem with our criminal justice system. We are taking people and charging them with victimless crimes, which I would say is ridiculous, and processing them through the system, causing a huge influx of cases, taking resources away from people who commit real crimes. And what I mean by a real crime is when there's a victim who's upset about something. So maybe some thoughts from Bill or Bob on that idea.
Well, that's a live wire. Bill, you can go first.
Didn't take you long to break out that hobby horse.
I'm sure you're shocked.
Yeah. Well, here's where to jump in on that. I guess one thing to approach it as, and let's get deeply philosophical, and then I'll come back out quickly. But we all have an obligation as citizens in a constitutional republic to, through the election of our representatives, our participation in our representative democracy, to work on developing policies that help our society be as good a society as it can be. And now, I'm not saying good necessarily in a moral sense. I'm talking about good in a Socratic sense or an Aristotelian sense, and understanding what is the highest, best good of being a human being. And so we make decisions, we make policy choices, and among the policy choices that we've made is that we do criminalize drug use and drug possession. But recognizing, too, the initial approach to the use and possession part of criminal offenses, aside from sales and trafficking and attendant crime, the criminal justice system here in Arizona, at least since 1996, has been focused on treatment first. So even if you wanted to say that we as a society here in Arizona should have more of a treatment or a therapeutic approach to dealing with substance abuse issues, we've been doing that. In fact, one of the biggest areas of diversion and deferred prosecution programs at the county level is in the area of drug use and the co-occurrence of serious mental illness at the same time, which is, it's incredibly difficult. I mean, imagine a criminal justice system that has become a default provider in many ways for critical care, either for substance abuse or for serious mental illness, trying to make those distinctions about what are we presented with here. Are we presented with someone who just likes to commit crimes? And if you legalize drugs, well, they'd go find something else illegal to do. Or are we dealing with someone who in the first instance does have an addiction, a classic addiction, in which case if we're able to help them, we will never see them again in the criminal justice system, and they won't go on and commit other types of crime. And then you've got the other category of folks where you could say the crime that they commit is either drug motivated or comes out of drug use. Having said that, I think the most current statistic from the Department of Corrections that you can find in their at-a-glance reports that are published monthly is that 78% of those who are incarcerated in our prison present with a substantial or significant substance abuse history. But yet, less than 10% are incarcerated solely for drug use or drug possession. So I don't think you could necessarily say that drug use or the criminalization of drug use drives everything else. There's an aspect to that, certainly. I would say that because of our efforts to divert and engage in deferred prosecution to try to get people the help they need, that the majority of the cases that we're handling within the criminal justice system aren't there solely because of drug use or drug possession, though they may be related in a lot of other ways.
Yeah, I'll pick up on that and kind of give another perspective. What's interesting is I think both Bill and I come from the idea of what is the best public good. Now, that may be a debatable point, whether that should be the focus of what you should do and whether that type of social engineering is an appropriate role for government. That's a real libertarian discussion about that. I do think there is one very important reason why it's good to have drug laws and criminalizing drug laws, and that's so criminal defense lawyers like me can earn a living. Other than that, I don't see a great deal to benefit from it. There is a problem in this society with substance abuse. The problem is exacerbated very often because we want to use the criminal justice system to deal with what is a social problem, a substance abuse problem. And the worst substance in society, quite frankly, and I've dealt with methamphetamine cases, methamphetamine defendants, heroin addicts. I personally like heroin addicts. They're usually pretty mellow. I mean, they're kind of nice, actually. Give me a heroin addict over an alcoholic any day. It's alcoholism. Alcoholism is the worst substance, and a lot of times the argument gets made, well, alcohol is used because it's legal. That I think is partly true. I also think it's used because it is so readily usable. In other words, alcohol is one of the few drugs where the negative effects of the drug are alleviated by taking more of the drug. Even heroin addicts need to stop it for a little bit and that kind of thing. So this society needs to deal with substance abuse, and I don't think criminalization is really the best mechanism, despite what I applaud what Bill does in terms of focusing things, kind of this drug court idea, getting people into treatment by the sanction of criminal justice. That can have a good effect on people's lives. But fundamentally, I think there has to be something else done. Now, if you don't want to legalize drugs, there is a middle ground here, and that is decriminalize drugs, which means you use civil forfeiture laws to go after people who make large profits on illegal drugs. You grab their yachts, you grab their houses, you grab their Porsches, and you just pay for the entire thing. You forfeit everything and use the proceeds to pay for enforcement and also for drug treatment. That is a way that you could actually, if you don't want to just say drugs should be legal, you can decriminalize it, use a different mechanism where there's a lot less constitutional procedures and a lot less expense to get after the trafficking, and then focus on treatment for the lower level drug users. Now, what that will leave you with is very often without a mechanism that can compel people into treatment, such as what Bill has talked about, getting people into treatment with the kind of the threat of prison time, and there's all these different diversion programs and things like that. You will probably lose that. And I think as a society we have to accept that there are some people that are not going to be helped, that some people just wish to do that, and they're kind of lost souls. And that's what you have to accept. And America has a hard time accepting that in our background. But some people you're not going to be able to save. But I think the social benefit from that approach is greater, and I think that's where Bill and I will disagree about that. But as long as they are the way they are, you have my information in case anybody here needs to hire me for a drug crime. I'm here, and so that works perfectly fine for my business model.
I think I could get some agreement here. Let me try real fast before we move on to the next subject. Agree or disagree, if we want to really fix this addiction problem, we got to make some strides at reversing what I would call the breakdown of the American family. Do I have agreement or disagreement on that?
A very strong agreement, and in fact, that's it's another facet of what we were talking about, that whether it's alcoholism or drug use or engaging in behaviors that are antisocial, that have a negative impact on others, I think we do have agreement that at the most fundamental level, the place where social controls are taught and reinforced is within the family, within a religious community, or within the municipal community. That's the way it used to be. But we've done a very good job in this country over the last 60, 70 years of breaking down the family, the church, and the school that used to teach the types of lessons that that helped people, lack of a better term, control their passions. And that's what's necessary for a constitutional republic to be successful too. And I'll throw out the virtue word. When we were formed as a country, founding father after founding father after founding father noted that in order for this to work, you're going to have a virtuous citizenry because that's who your leaders are going to come from. And if you don't have that, you're going to lose some of the basic building blocks of what it takes to be successful. And so I absolutely agree. Just about anything that we would point to in the criminal justice system, without engaging in reductionism, we could work it back to saying that a stronger family setting would have been beneficial.
And I'd extend that too. I have a great fears about the lack of civic engagement. You can start with the family, you can broaden it out. I mean, membership in the Kiwanis Club, the Rotarians, everybody's membership is down. Organized churches are down. And leaving aside what people feel about the theology of one thing or another, it's people who are getting more and more divorced from a sense of community and a sense of broader community in the nation. And my example is, okay, you got a couple people in the Kiwanis Club. Now, I've never been a member of the Kiwanis Club. It never turned me on, but okay, I have enough other organizations. And they sit there, you got a Democrat and a Republican, and they'll argue about everything. And then, you know what they do? They both go work on the float. Okay? That has value. And that kind of forum for discussion is being lost, and then it gets really channeled and kind of put in these different websites or whatever, and so everybody just reads their own blogs, and you get people more and more separated rather than coming together. And I think there's a real loss there, and I think people feel a loss. And that's what you get with suicide rates and everything else. And even the desire people have to turn to drugs in the first place is this lack of engagement and connection with other people, which I find problematic. It's interesting. The people you here are the kind of this. I'll say you're the social elites. You've bothered to come to a seminar like this and actually talk with people about this. Everybody else is sitting at home tweeting, and I think that's problematic. So the value of the discussion is getting lost more than anything else, regardless of what you conclude or not.
Yeah, before we move on to the next topic, I think it is interesting to just pause and note for a second that the libertarian, the conservative, and the progressive for today's discussion all agree on one very important part. We need to do something about the breakdown of the American family, because I think even though I sort of threw the question at Bill in terms of addiction, and Bill expanded it out to basically all crimes, I got to say I totally agree with that. We all get pre-sentence reports on felony cases before a judge sentences somebody. We get this report that's sort of an overview of the background, history, how they were raised, all these various factors, and these reports have common threads that run through them. I can tell you it's very rare that I see somebody who I would call a bad guy or somebody really facing lots of long-term addiction problems who had a good family upbringing, a mom and a dad who were both interested and engaged. It does happen. We see it. We get people from good families, but I would say that's probably the extreme exception rather than the rule. What we do about that is a different question. So moving on, Bill, so if we said you're going to be the iron-fisted dictator of the criminal justice system for a day, and your desire was to improve the system, and you could do one thing, what would you do?
I would re-engineer the current incarceration experience for those who are in prison. Right now, about 50% of those who are there for the first time. Now, under Arizona laws, the vast majority of them are not there because they were convicted of their first felony. They've had previous felony convictions, or they committed a violent crime, or one of another very narrow category of offenses where you can be sentenced to prison even if it's your first offense. So a vast majority have done other things, but they're there for the first time. So then the question becomes, what do we do with someone while they are incarcerated? And I would say that we probably can do a far better job at providing substance abuse treatment, recidivism reduction programs from the point of admission, instead of just waiting until a particular time before they are released and reenter the community. And the reason why I would focus on that is that we have data now. We have objective data that identifies successful programs and successful approaches to dealing with offenders who may have an issue with recidivism, and as I mentioned, may have an issue with substance abuse, may have an issue with the fact that nobody taught them that you should treat other people nicely. You should wait your turn. You should be patient. They never taught them that. So we have programs now that we are seeing working on reentry. We are seeing working on diversion and preventing people from committing another felony. So I would re-engineer that entire experience. If we were successful with just half of those who are there for the first time, that's over 10,000 people. You could shut down entire prison units and then refocus and redouble those efforts. And it can work. It's working in small programs at Lewis Prison and at Perryville. So I would expand those, and I would re-engineer that experience from day one of admission.
If I can take you back. Yeah, I think what Bill says makes a lot of sense. Of course, you have a certain problem, which is, as he alluded to at the start, you have how many different jurisdictions and budgets. There is a great economic benefit to not sending people to prison. The trouble is, who gets that economic benefit? If you had a more integrated system where the Department of Corrections, I mean, not that I want to increase the size of the Department of Corrections, but if you gave the Department of Correction an incentive to keep people out of prison, they would have the budgetary incentive not to do it, but it doesn't work that way. Budgets don't work that way. It is incredibly expensive to put people in prison, and you can hire numbers of probation officers to supervise people for a fraction of the cost it takes to put them in prison. And there's social benefits and good to that, even if only half of them succeed on that probation, which was the original idea of intensive probation. You can have great social good with that, and not enough of that's being done. And part of that, I'm thinking, is because of the budget mechanisms that go with all these things, and that's kind of hard to set up. So.
Well, I want to say, because I mentioned at the beginning about where the different actors are in the criminal justice system for Arizona, and to Bob's point about the budget authority and how that works. So I can't control how many cases get submitted to my office. We average about 50,000 submittals a year, and we average charging about 30,000 cases. Now, we're a county of over 4 million, so we have to keep in mind scale a little bit. But there are about 37 different local, county, state, and federal law enforcement agencies that work within Maricopa County. Each one of those municipalities has a separate budget to fund their police department, to hire detectives to train them, and to charge them with their enforcement priorities, which may or may not line up with what I see then county-wide as issues with crime. The cases that I then prosecute, if I put someone on probation, that's a county budget. And there is some monies that come from the administrative office of the courts and the state court budget, but it's predominantly a county cost. So if I want to offer probation more, I'm going to increase county cost on that. Now, this is not my calculation. We don't do this. But if I really wanted to say, you know what, we want to save money at the county, so we're going to stop offering probation to anyone who is prison eligible and then ship them all off to prison. Well, the economic impact to me then in reality is going to be those people go to prison. If we do not have successful programs and treatment provided at prison, then when those individuals come out and re-enter the community, they're going to be re-investigated, re-arrested by a municipal agency, resubmitted to the county for prosecution. And because they've been to prison before, we're probably going to look at another prison resolution. So they're incarcerated in the county jail longer while that case plays out. And then we send them back to the state for a longer period of time. And we're on this treadmill, merry-go-round, however you want to fashion it, in part because of how that budget is broken up. If the Department of Corrections maybe was responsible for supervising people for a longer period of time after they were incarcerated, and therefore had to bear the brunt of successful reentry and keeping people on the straight and narrow, they might do more at recidivism reduction programming in the first place. But that's not how we're currently engineered, and that's sort of some of the budget impacts.
Yeah, I mean, let's kind of just do a little bit of theoretical math. If you have a probation officer who earns, what, $60,000 a year, and he can keep 10 people from that cycle, not only do you not have millions of dollars being sent for incarceration, you have 10 people who are out being forced to do jobs and supporting their families, providing money for their kids. There's all these other social benefits that then they don't go on county welfare and other county systems as well as state systems. There's all these other costs that are embedded, and it's a budgetary structure. I mean, you can sit there and go to a committee and talk all you want about what the criminal justice should be, but you really want to affect change, get on the appropriations committees and the budget committees, because they're the ones who can engineer this stuff.
So sounds like money's a big issue here. I just got a great idea. The last time I checked on this, and I'm sure this number is now outdated, but the last time I checked on this, we are blowing $69 billion, with a B, billion dollars a year fighting this stupid-ass drug, oh, did I say that? I'm sorry. Fighting the drug war. $69 billion a year. I get that figure from a group called LEAP, Law Enforcement Against Prohibition. They came out with that figure of $69 billion a year. So I'm wondering, would it make sense to end the drug war, save $69 billion a year, and then use some of that money to do exactly what Bill wants to do, create fantastic rehabilitation programs for which we apply them to the only people left now, the people who didn't commit the victimless crimes, the people who committed the victim crimes, the people I think we most care about, the people who murder and rape and rob and all that stuff, and try to rehabilitate those people. And I bet we still have money left over that, I don't know, maybe the people who made the money could keep that, or we could put it towards schools or something other than putting pot smokers through the justice system. Thoughts on that? Just wondering.
You know, well, it's funny. It's
The Law Enforcement Action Partnership.
Oh.
yeah. They well, and there's a lot more they need to change, including their statistics. I actually had the chance to debate the founder of LEAP a couple of years ago. He got his $50,000 to start from George Soros to start that. And his entire story was he felt guilty about arresting college students who were smoking marijuana, and so he's now been on this crusade. I think he ought to go become an addiction counselor, and he'd have a greater impact. There are a couple of false assumptions in the argument that if we stopped enforcing laws against drugs, whether decriminalizing, possession or use or otherwise, that all of a sudden all of those dollars would not be needed to prosecute other crimes. You have addicts who do commit crimes, and those crimes will still need to be prosecuted. And we don't push pot smokers through the criminal justice system. The overwhelming number of individuals who are initially arrested and have a case submitted for marijuana, we wind up dismissing the case with prejudice because they successfully complete a treatment program, or at worst, they'll wind up with a misdemeanor. Very few ever go through an entire prosecution process, formal prosecution, and wind up with a felony. 0.5%, less than 220 people are in prison today for possession of marijuana. And because of our treatment first approach, in order to go to prison for possession of marijuana, some really bad things had to happen. This is your third or subsequent, in reality, probably your fifth law enforcement involvement for possessing marijuana, or you were pled down from drug sales or drug trafficking. And we do have a problem with cartels using Arizona as the main thoroughfare for drug trafficking in the United States. So that's sort of the reality. And when we talk about our criminal justice system, we have to keep those other aspects in mind too. Because if we want to go through how we have our criminal statutes set up, we need to use a scalpel and not a sledgehammer, because at the end of the day, we still want to be able to live in a safe community, and we don't want to provide the wrong incentive for criminal activity either. So that's the long answer. The short answer, it's 69 billion, whatever. Well, that's nationally, and that enforcement of drug laws is going to differ from state to state. So overgeneralizing that also means you really can't provide a much more focused approach if you wanted to change the approach.
Well, look, I mean, I kind of agree with Bill that you're not all automatically going to get, $69 billion in your piggy bank right like that if you did that. But there are these questions about these mechanisms. I can give you something of personal experience. We're talking about marijuana laws, simple possession of marijuana laws. When I was in the Maricopa Legal Defender, I was doing death penalty defense, but we all had to take our turn down in early disposition court, where there was 3 full-time lawyers there, and you would, in a day, represent about 30 people during that day, and you would take them through early disposition court. And what early disposition court was, you got caught with a joint, and you had to pay, at that point, it was about $1,250 in fines, fees, and surcharges. Now, as a public defender, my training budget partly came out of those very same fines, fees, and surcharges. There's a lot of county government and functions that actually get financed through those fines, fees, and surcharges. So you'd have a defendant who would sit there and say, wait, let me get this straight. You mean I have to pay $1,500 and $1,250 for a fucking joint? To which I felt like we're saying, well, yes, sir, but you should be happy at that because your lawyer gets a benefit from that because of my training budget comes out of that same fines, fees, and surcharges, okay? The point is there's a lot of people now who are committed to this budgetary structure for enforcement of drugs, and that kind of fundamentally has to change. And those attitudes have to change. So, if you're going to make marijuana legal, which I think is what society's doing, and I generally agree with that, well, you're going to have to figure out a new budgetary mechanism. Which means, by the way, you might have to be more honest with people about how much criminal justice costs, and that, gee, you want to have this punitive model, which I think Bill, at least partially, is in disagreement with, at least across the board. You want to keep this punitive model for drugs or everything else. People don't realize the cost of that, which, by the way, is why the Koch brothers, who are believing in small government, and although they're conservative causes all over the place, have gotten behind things like criminal justice reform and shrinking the prison industrial complex because of their ideas about government should be smaller and less intrusive in people's lives. And my argument is, again, yeah, that's great, but you also have to be honest where these fines, fees, and surcharges are going and how that's a kind of an unknown tax on people that finances a criminal justice system that if people knew the real expense of all this might make other policy choices, which I think would be healthier policy choices.
And I'm going to, before I ask Bob the sort of king for a day question, what would he fix? Just a footnote, I will say, just as someone who defends people who get charged with marijuana, you couldn't get charged in a better place than Maricopa County, because in fairness to Bill, just for completeness, if you get charged, if you come into my office and you say, hey, I'm here because I got charged with a felony for first-time possession of marijuana, and it's in Maricopa County, myself and the other 2 criminal defense lawyers at my office are going to send you away. We're going to say, you know what, you don't need a lawyer. Just go down there because we know how Maricopa County deals with this. They're going to give you task diversion, and as long as you're willing to go through that program, which incidentally, you could actually get a medical marijuana card and continue to smoke marijuana and still go through the program. I think you can still do that now, but that's just the state of affairs in Maricopa County right now. But in fairness, that is not the case in all counties. If you get charged in Yuma, like a lot of people do, because they come through that checkpoint in Welton, they come through California, and then there's a checkpoint as they're coming through Yuma. And if you get charged with possession of one marijuana cigarette there, you are going to get charged with a felony or a misdemeanor, but they are not going to send you to task diversion. They are going to ask you to plead guilty to a misdemeanor, and they are not going to budge from that position. You're either going to go to trial or you're going to plead guilty to a misdemeanor. So this is some prosecutorial discretion that frankly gets exercised in Maricopa County. I think that is the right thing to do under the circumstances. So in fairness, I wanted to put that out there. So Bob, you're king for a day of the criminal justice system. You want to improve things. You can make one change. What are you going to do?
Get rid of mandatory minimum sentences.
That's where I was going next. Bring it, brother.
What mandatory minimum sentencing does is it takes people who have other factors in their lives, other mitigations, and it puts them in a category where the judge has no further discretion to tailor a sentence that would be appropriate. It's also part of a general model. If you talk about the purposes of criminal justice, it reinforces the retributivist punitive model as a purpose rather than rehabilitative or other type purposes of criminal justice. And what it serves to do more than anything else, actually, is it gives prosecutors an unfair advantage in plea negotiations, because what they can say is you can face the mandatory minimum or you can accept this plea. And it leads, I think, ultimately to higher sentences. And personally, I don't think there's any need. If there's something to be bad enough that they're going to get a big sentence, judges, people have this image that judges are these kind of, soft-hearted, wimpy, liberal-type people running around. Maybe I'm just not that good as a lawyer because the judges I get never do that with me. So, they tend to be, even when whether they're Democrats or Republican or anything else, they tend to be personally conservative people. That's how they're chosen. They tend to reinforce the boundaries of society. They want to do good. And I agree with, by the way, what Marc said. I have never known a judge to be inappropriate, that I thought was corrupt or anything like that. I've never had an experience in America of a judge like that. So, but these people tend to be personally conservative people. And they understand that some people need to go to prison. Most criminal defense attorneys will tell you, yeah, some people need to go to prison. They're usually Marc's clients. My clients never do. But at any rate, leaving that aside. But yeah, so if you can, I tend to be with the idea, let's go back and give judges the discretion to make fair determinations and fair decisions. So things like mandatory minimums, 3 strikes laws, all of those kind of things. The Supreme Court has upheld a 3-strike law with some poor guy who had 3 shoplifting. He had, I think the amount he ever took was $229.35 in all the crimes he ever committed, and he was looking at a decades-long sentence because it was 3 strikes. Those kind of arbitrary lines just don't serve society in the long run. So that would be probably the one thing I would do.
Bill, thoughts on mandatory minimums?
So we don't have a 3 strikes law like that in Arizona. And the presumptive sentencing system that we have within Arizona was created out of the experience of indeterminate sentencing. And for the experience here that we had in Arizona, where judges could sentence someone for some offenses, say car theft, probation, to 30 years in prison. If you were committing that offense in South Phoenix here in Maricopa County, you might get probation. But if you were the same type of demographic offender, same type of criminal history, same type of scenario of having committed that offense, you could get 30 years in prison in a rural county. So the presumptive sentencing system was established in order to guide the judiciary in what types of sentences the people of Arizona wanted to see through the exercise of the legislature. Keep in mind, too, that sentencing system is not something that prosecutors dreamed up and are able to impose on defendants. This is something that has gone through the process of the legislature telling the judiciary that this is what we want to see for these types of offenses, classification of felonies, and for these types of offenders committing this type of harm. Within each one of those particular categories, too, there's broad discretion. There can be as much as 10 to 20 years from an absolute minimum sentence that could be imposed to an absolute maximum sentence. And courts are free to move within that, subject, of course, to a negotiation between the defense and prosecution. I would also say, as one last point on this, that sort of the certainty that comes from a defense attorney who can look at their client's record and what a prosecutor can look at, given someone's criminal history, the type of offense they committed and harm to a victim, we know when we sit down, all right, if we go to trial, this is what the range would be. And we could even agree that this is probably a likely sentence that could occur. And then we'll have a conversation. Is that just? Is that what this case really calls for? And from my experience as a line prosecutor, most of the time, me and the defense attorney would say, you know what, no, what's probably a better resolution here is if we reduce the classification of the felony, narrow the range that could be imposed, and we will work out what a just resolution should be. Now, there are some who will argue that, well, the judge should do that. The judge does not have the time, nor does the judge have access to all of the information that the prosecutor and the defense attorney will have in going through that process and coming up with what that resolution should be. The judge is going to get a pre-sentence report, as Mark mentioned earlier, and that's pretty much going to be the source of the information that they have. But that pre-sentence report is not going to include all of the police report. It's not going to include all of the conversations that the state has had with the victim. It's not going to include all the conversations that the defense attorney has had with their client. And it certainly is going to miss out on the conversations between the defense and the prosecution. And that's, call it rough justice if you will, but that's really where you have the human contact trying to figure out how should this case resolve.
Well, okay. Well, first of all, there's a distinction here between a mandatory sentencing scheme and a presumptive sentencing scheme. My issue was with mandatory sentences, which are statutory required. Now, talking about a presumptive sentencing scheme, I don't have a problem with that in concept. It does create more uniformity. My problem with Arizona and most states is they are presumptively too high already. So if you could lower the presumption a little bit to allow for a little bit more other options, that would be good. The other problem that I have is the discrepancy between the time a person looks at if they go to trial versus the time they will get under a plea, which still may be quite large, really squashes any intelligent person, guilty or not, is going to have to think twice about whether they're going to go to trial on certain charges. And I think that is just problematic because you're eroding people's desire to exercise their right to trial. It is a huge risk if you exercise your right to trial. And that gets people really scared. Now, what Bill is talking about is this relationship between prosecutors and defense attorneys. That's perfectly fine, and I think that's a good part of the system. I still think you should give the final thing to the judge to make the decision, and that still allows for that exercise between the defense attorney and the prosecutor. But let's be real about something else. Most plea agreements are not bargain for exchanges like we learned in contract law, or if you watch Paper Chase. They're adhesion contracts, which means you have no choice. This is what you're offered, and if you don't accept it, your client is going to face really bad things. So most of my conversations with my clients are, this plea sucks, but it sucks worse if you go to trial. And that's about where it stands. And I think that's a little problematic, just in the concept of preserving people's rights to trial and then, frankly, keeping prosecutors on their toes to where they can really try cases. I mean, you get cases that go to trial, and yet prosecutors just been pleading their whole lives. And defense attorneys too, by the way. You have defense attorneys that haven't been to trial in years. Well, that's problematic, man. These are perishable skills. So I think that's a problem. Okay.
So once again, Bob stole my thunder here. Where I was going to come in is just kind of mention that I don't know if you guys know the stats on plea bargains, but they're in the high 90% range of cases are resolved by pleas. I'm not saying all of them are due to the mandatory minimum, but a lot of them are. And so let me just present the problem, and I could use many different varieties of cases, but imagine your typical self-defense type of a case, maybe even with a firearm. Say you're carrying a firearm, and maybe there's 4 or 5 people, and there's the typical situation you might expect, and somebody puts their hand on their firearm and says, "Hey, leave me alone." And the next thing you know, maybe there's 3 or 4 people who are maybe even making up a story. Hey, he pulled out his firearm and he pointed it at me. And maybe you get charged with a very serious crime like aggravated assault, which is a dangerous felony in Arizona, and it requires a minimum of 5 years in prison if you lose, even if you got no priors. But imagine you think you have a pretty good defense. You say, "Hey, look, I think I was justified here. Not only that, I got a couple of witnesses on my side, and maybe it's a case that really ought to be tried." There are a lot of close calls like that where my client might say to me, "Hey, Mark, I like to go to trial. What are my chances I win at trial?" And I think most defense attorneys probably don't get any higher than 50%. I can tell you at my firm, nobody gets higher than 50% chance at trial. But imagine I could actually give you something even higher. Imagine I could say, "Look, you actually got 90% chance of winning that trial." Say it's a really strong case, 90% chance. But guess who also knows how this works? The prosecutors know how this works, right? So what they say is, look, if your guy loses, he's going to get somewhere between 5 and 15 years in prison. Here's a plea plead guilty to this, it's maybe a Class 6 felony. You'll be considered a felon for the rest of your life, and you're going to lose your right to keep and bear arms, maybe forever, but because it's a state conviction, you may be able to get them back. But you're guaranteed probation, 100% guarantee you're not going to prison. So here's a case that really ought to be tried. Maybe it's a close call. But see, if we go to trial and we lose, even if you can convince the judge that, hey, judge, this was a close call, my guy maybe made a bad judgment or something like that, the judge is going to say, maybe I agree with you and I wish I could give you probation, but I've got to send you to prison at least for the 5 years. And the prosecutors also know this. So it's fairly, I don't want to say frequent, but it happens often where a prosecutor will sort of say to me, hey, look, Mark, your guy can't turn this deal down because the risk is too high. And the risk in certain types of cases, like possession of child pornography cases. Can we even talk about this? Can we even talk about it? Can we even raise it? But imagine somebody who's really not guilty of this crime. Often people get charged with having 10 pictures on their computer, and because of the way our sentencing structure is, you're going to get 10 years for each picture stacked on top of each other 10. So you're going to get 100 years. If you go to trial and you lose, the best you're going to do is 100 years. And what if you're saying, look, I'm not the one who downloaded the pictures. Someone else had access to the computer and they downloaded the pictures. And now here comes the deal. Maybe it's a probation deal, like I got not too long ago on one of these types of cases. You are not going to turn that down, and you're not going to turn it down even if you're innocent. And that's the issue with mandatory minimum. At least that's my take on it. And have we killed that issue, or you guys have other comments on that one?
Well, I would just say that you ended on a bad note, because when it comes to possession of child pornography, we're also dealing with a broader problem of trying to eviscerate the marketplace for the sexual exploitation of children. So that's one where I want to apologize at all for policies or how we prosecute those cases. Given the burden of proof for us to meet as the state in doing that, we're not guessing at whether or not someone had child pornography. And typically we're dealing with individuals who have thousands of images, hundreds of movies, and have categorized them into some of the most sickening categories imaginable. Okay, so we'll get away from the pariahs. When it comes to the use of deadly weapons, yeah, we as a society have said if you use a deadly weapon, there are significantly more penalties that are going to be involved. And the one postscript I'll put on all of that too is that the charging standard for a case in general among prosecutors in Arizona and really across the country is whether or not there's a reasonable likelihood of a conviction, whether or not the state has sufficient evidence to prove each element of each charge beyond a reasonable doubt. And that certainly is the guiding principle that I dealt with when I was a line prosecutor, and that is still applicable in the office. So if we're dealing with a case where there really is an open question about whether or not someone is guilty, we shouldn't have charged it. And Mark and I have worked on a number of cases together too, where there were some additional factors involved that called for mitigating the potential outcome of a case, but underlying guilt or innocence happens very rarely. And even then, I as a prosecutor and prosecutors I supervised, if you've got that kind of information, we want to know it. Because the last thing we want to do is go through the expense and preparation for trial only to get there and roll the dice and see, well, let's find out what's going to happen here. No.
So we got 3 minutes left. I'm going to give Bob the last word because we're pretty close to out of time.
Look, I don't doubt the sincerity of what Bill says, but don't you realize that's a skewing of the system? We don't allow prosecutors to decide who's guilty or innocent. We're supposed to allow a criminal procedure and judges and juries to decide that. And no, acquittals still happen. But basically, I was going to say...
So do wrongful convictions.
So do wrongful convictions.
We had first-degree murderer wrongfully convicted and sentenced to death in Maricopa County.
I represented a bank robber who... I represent a bank robber who is wrongly convicted.
Wasn't on your watch.
And it took a long time to get that overturned. So yeah, these things happen, but it's the skewing of the system where everything has gone in the realm of the prosecutor versus versus kind of what I would say should be a more balanced system that actually has more trials, and you know, it's not just what the prosecutor says. I mean, there's a lot of times I've found prosecutors that misread their own cases a lot. And so that I think is it. Bill started this conversation with something that I didn't challenge at the time. Public safety is the first responsibility of government. I'm not totally sure I agree with that totally. It is an important responsibility of government, but if you go back to what the purpose of our government is to diversify power and to protect the individual from the power of the state as much as to allow the government to exercise its power. And so I'm not sure I would say that public safety is the first responsibility of government. I think procedural process is the first responsibility of government.
Two good lawyers, two good legal minds. Let's have a round of applause for Bob McWhirter, Bill Montgomery. Thanks for coming, guys. Thanks, guys. You guys were great. Excellent discussion. I think we're out of time. We got to